Rules of the Startup Game. The Startup Guide to Startups.
Hello and welcome to the third episode in this special series. If you've been following us since the beginning, you probably now have a clearer idea on what kind of structure to pick for your fledgling business, corporate or partnership. You also have a better idea on the raft of government permissions needed depending on the industry you are in. At this point, I assume you are ready to hire employees, sign up vendors, and get to work. Well, let me warn you, you're about to be confronted by the very confusing, complex world of contracts. Well, to run through the do's and don'ts of contracts, we invited several startup entrepreneurs to put their questions to veteran lawyers Anand Desai and Karthik Ganpati. Interestingly, the one common question they all posed at first was whether oral contracts are valid or not. Here's Karthik with some answers.
Under the Indian Contract Act, a contract can be an oral contract as well. So what you require for a contract is that there should be two parties competent to contract, there should be a consideration, and a valid objective for which the contract has been entered into. Now, to the extent you want a written contract, that is only to aid your memory. It is so that you agree specifically with respect to the terms of the contract, and you don't have a point in time much later where memories have begun to fade, and then you have to quibble over terms of the contract. So that's really why people ask for written contracts.
Can email be a binding contract in terms of with employees, with vendors, or anyone? Just an email would do?
Email itself is just a proof of the terms on which you've agreed. Right? There's no real contract that you've signed into, so it's not something that you've actually signed. So I would treat the email more as sort of the backing to an oral contract as opposed to the contract itself.
I'm a single proprietor right now and have a very small startup. Now, I've been told by a lot of people to get a partner on board. So when I am in the process of getting a partner, what is the kind of contract that I should have for a partner, considering various reasons that, for example, if I get a partner on board, he learns the business, and what if he decides to move out and start on his own?
When you look at a company, because it's a limited liability entity, you have shareholders in the company. So you could treat this as either sort of a shareholders agreement between two people if you're doing the company, or you could treat this as the requirements of a partnership deal. So what you would do in the context of a partnership. So things that you'd need to do is to first highlight the roles of the people, highlight what people will bring in terms of capital or IP. You could also have management with respect to whether there will be affirmative vote rights or not. You would have circumstances of dissolution of the partnership, which is under what conditions would you dissolve the partnership, under what conditions would somebody take a back seat, where you would define your roles, and you would have dispute resolution. Right? Dispute resolution being if there is something that comes up where you don't agree, as happens in all relationships, how you would sort of go through that. Right? But in general, what you would try and protect is the way you run the business. You would also try and have non-compete, non-solicit obligations. You would also try and have obligations that make sure that all the intellectual property belongs to the business and not really the entity.
My question to you is very simple. Assume X was appointed the managing director of a company by Y. Later, it's found out that Y is not actually authorized or competent to appoint the managing director. Can X actually claim salary for the period that he worked?
Okay. So before answering that, to appoint a managing director, generally the way that you do this is you'd enter into a contract. A company would enter into a contract with the person for a managing director, or you would have a resolution that sets out the powers and responsibilities of the managing director. So let's assume one of these two things happened, right? A managing director, when appointed, all his acts will be valid until the time at which his appointment was deemed to be invalid, right? So in the fact situation that you had a person who's appointed someone else as the managing director. It was only discovered later that this appointment was incorrect, right? The managing director's acts from the time that he was appointed until the time that it was found that his appointment was invalid would be legitimate. Now the question as to whether he would be compensated for the acts that he's done. Well, unfortunately, the case law that comes to mind is all English case law, but it sort of applies equally with respect to India. Now, under English case law, the point is a managing director who's fulfilled a certain role for a point in time is due compensation under what is called quantum meruit, right? Or basically, for the time that he has been there, for the acts that he has been performed, he should be given some amount of compensation. What that amount is, it should be a reasonable amount of compensation, but he certainly is due something. It's because he's acted for the company has gained from his actions. So So it's not like you can just throw away everything that he's done. He does need to be compensated to a certain degree.
I have a specific question in terms of the employee contract. What are the things I should take care of, especially when the employee is exposed to the formulation, the production process of the company?
Now, in every case where you have a business which has a certain amount of intellectual property, the things that you should be looking for in a contract would be, first of all, a non-disclosure aspect of it, which essentially means that everything that they learn during the course of their employment is not something that they can disclose. You're going to also ask for IP assignment agreements. So to the extent you have these employees working on the business processes, if there is something that they innovate in terms of the process, you want that innovation to also belong to the company. So in your employment agreement, you will have an IP assignment clause that says that they will assign everything that they do or that they find out during the course of their employment to the company. In addition to this, you will have the usual non-compete and non-solicit obligations. Now, the non-compete obligation is one where it says that the employee, assuming that it's a fairly senior employee, will not go out and compete with the business of the company. Now, to that extent, the non-compete itself is subject to a bit of a question, because generally the Indian Contract Act doesn't allow you to have agreements in restraint of trade. So where this person is only sort of working in a place where he's got the training, it's very hard to sort of extend the non-compete out beyond the time that he remains an employee of the company. However, it's still possible. I mean, there may be reasonable limits to this depending on the process, depending on the facts. The non-compete is definitely something you should have. The last is the non-solicit. And you need the non-solicit to make sure that a reasonably senior employee who leaves the firm doesn't take away other critical people from the business.
I had a question regarding hiring part-time technology professionals. Let's say my startup hires a tech guy who is already working full-time with another MNC. Mm-hmm. So what kind of safeguards can I have in a contract so that all the intellectual property that is created is assigned to my company?
Well, I think the easy one there is to first look at the terms of employment that this person has with his current employer. So if the terms of employment that an employee has with his current employer is that he is supposed to commit all his business time or a sufficient amount of his business time only to that, then you can't really hire him as a part-time person. Right? The second is to make sure that this person also comes to you and says that he will not use any intellectual property or any confidential information that he knows from his previous employment in the work that he's doing for you. You need that clause in your agreement as well, a representation from him saying that, and a representation that he will not take any of your confidential information and use it in that business. Right? Because of the sort of the construct of your question, I'm assuming that this will be sort of a contract laborer. So it will be a principal to principal sort of relationship, not really a contract blue collar sort of relationship. Because of that, you will have your agreement will really be between the provider of a service and the consumer of a service. So it will be two principals, not as an employer-employee relationship. Which also means that you have the ability to have in your agreement terms by which you can stop the contract, by which you can disassociate yourself from him. You can claim some representations, indemnities from him. But the key here is to make sure that whatever he has with his current employer doesn't inhibit him from taking up another employment with you to do the kind of work that he's doing.
One of the problems that startups face, which is a recurring problem, is bootstrap budgets. Mm-hmm. So how can a startup look to optimize its cost when it comes to recurring contracts?
If you could sort of think about the clauses that you certainly must have or want to have, and those that you don't really care about, that's one way to go about it. So create a standard format template for yourself and then assess every contract that you get against that template. Some of the things that startups usually run into would be the requirement to maintain high levels of insurance. Right? That's something that happens quite a bit, where international service providers require you to carry very large insurance premium for the work done, for your employees, all of that. The trick over there is to tell them that this is not standard as far as the Indian market is concerned. We certainly don't need that. The other is the governing law and dispute resolution provisions, which Anand will talk about later. But the governing law and dispute resolution provisions could turn out to be expensive for you if you need to litigate that contract. Right? So assume that you're a startup, you have an agreement which says go to the US, to arbitration in the US, and there is a dispute that comes up. You actually have to go there. It's very hard for you to sort of walk out of that.
My question to you is regarding a commercial loan agreement with the bank.
Mm-hmm.
In case if I fail to pay the bank the loan amount, will they be entitled to use my IP? And the B part is if an investor comes when I'm under a loan, is there some binding thing where I can settle the loan with the bank and have a joint venture with my partner?
It depends on what property the bank has secured for the purposes of this loan. Fortunately, we have somebody who knows the banking insider here. So Pramod, my partner, does a lot of work with banks and was formerly general counsel himself in a bank. So maybe you want to take that question on the banks.
Yeah. So if you've given indeed the security of your IPR, the bank, in case of your default, can indeed seize the IPR and sell it to somebody else. The other side of the coin is that if you default to a bank, really the industry has now coalesced around what is called credit information bureaus. So that sort of default history now enters the credit information bureau system, and that will hamper your taking future loans unless you sort of adequately secure and give further security to the other lenders. So defaulting is something which can actually come back to haunt you later on, is the sort of thing which is coming around. In terms of being taken out or when you have a new partner coming in, I guess it's the end use you negotiate with your partner whether it goes towards prepaying the loan or not. Prepayment clauses are something which banks put in their loan agreement. So you really need to see whether there's a prepayment premium, there is some additional charge for having to pay back the loan earlier than it's scheduled. So those are the things to watch out in a loan contract.
So we're good? No more questions for me? Great. We can get Anand up.
Up next, DSK's managing partner Anand Desai fields questions on vendor-supplier contracts, IP and dispute resolution clauses.
Rules of the startup game. The startup guide to startups.
Today we're discussing the do's and don'ts of contracts. Earlier in the show, Karthik Ganpati of Indus Law covered the basics of employee contracts and also financing agreements. Now, DSK Legal founder Anand Desai is about to take questions on vendor and supplier contracts and IP and dispute resolution clauses.
My question related to the outsourced manufacturing contracts when done with foreign vendors, specifically, for example, Chinese vendors, because there's a lot of apprehension a lot of times that some unauthorized manufacturing can be done by the vendor without informing the owner of the IP and be sold to some other markets. So how to take care of those things?
So first, on a broad principle, whichever country you are dealing with, try and figure out what their laws allow you to protect and not protect. Because some countries are not very strong in IP protection. So irrespective of what you write in your contract, you can't enforce it. That's one. Generally, through contractual provisions, you try and be as specific as possible, one. Secondly, give as little as possible. Because the reality is, as an entrepreneur, it's easy to say, I will give you so much information and you give me so much back. Coca-Cola, I think, is a classic case of a formula that's been protected for years and years, as you all know. And the value proposition of Coca-Cola as a brand, because of that formula, is phenomenal. So how much you need to give out, or how much can you condense into a process which you can share, and that's enough to get your work done. That's first. Also, the applicable law that you want to put into the contract and how you're going to enforce that contract. Is it arbitration? Is it arbitration outside the country both of you are in, which is called international arbitration? These are questions you need to ask. So like I said, there's no easy answer, but these are questions to ask and try and get as clear as you can in which way you're going.
Mr. Desai, as a startup, when we supply to large buyers like MNC retail giants, typically they have a very standard agreement, contract forms, which are one-sided. So in such cases, how do we protect our...
So I think it depends on the bargaining position. If you have no bargaining ability, and believe me, India, for many years, we all believed we had no bargaining ability with large MNCs, like you said, from the US, Europe, etc. I think that's changed. Because I think there's a value proposition that you're offering, which is why they're coming to you.
MNCs in India will tell you that, oh, this has come from Hong Kong, it's our global template. This is from our Asia Pacific head. This is the template you have to go with. So there's nothing you can do, but you have to sign on the dotted line with these, since you're a service provider to corporates. But what you also try and do is you make a local addendum or an annexure that protects certain rights for you, or gives you extra fees for doing something, or gives you a compensation in some other way in a very restrictive clause that might be there. So you request an annexure which the local CEO agrees to sign with you. That's how you try to get in your point of view. The contract will not change. They behave as if it's part of the 10 Commandments.
Yeah.
The principle remains the same. Are you in a bargaining position or not? And what do you really want? You can put it in the contract, you can keep it. I'll give you an example. For example, the large hotel chains, I don't want to name any, they always come with a standard contract. But the reality is today, they see India as a huge market. When a landowner is talking to a multinational hotel chain, they actually have a lot of bargaining ability. And that's a reality. So it's easy to be told, guess what, this is my contract, you sign it, versus being told, okay, I'll go and ask somebody else, they will come around.
In terms of, like I have given out a third party, to develop my own tool, which is basically into social media. So how do I protect that, looking into the perspective that it's a third party that I'm giving it out to? And second part is on payments. Now, even if it's clearly mentioned in the contract that, payments should be coming in a particular time period, but it doesn't. So is there a particular dispute or a dispute resolution that you can actually go ahead with respect to the clients?
So unconnected questions.
Yeah, there are two unconnected questions.
So the first one, again, is a question of contract. And like I said earlier, how much are you giving him in terms of information to develop? What is he giving you? Is it really protectable? Because a lot of people think IP is so wide, any thought in their mind is protectable. That's not the case. It has to have some application, it has to be of some use, it has to be unique. If you fulfill those criteria, through a contract you can ask the vendor to provide you with a product of XYZ, meeting your requirements, you'll put in your standards, etc. You'll also say you cannot use this for anybody else. Now, if he tries to, that amounts to infringement of your rights, one. It also amounts to breach of contract. Breach of contract is sometimes easier to prove because infringement means you have to first show that you are the primary person, the first person entitled to that right. It's a protectable right, which is sometimes not so easy, believe me. And the challenge also in that is if you go to court, guess what? You're disclosing that to the whole world. So there are methods used where courts will tell you, put in a sealed envelope, give it to the judge, he will read it, but the reality is the other side has to read it. The other side has to be able to answer it. Without reading it, he can't answer it. So contractually, if you can protect it, it's safer. Your second question, how do I resolve disputes? Honestly, there are many, many routes available depending who you are in terms of which category you fall under. I know there's the MSME Act providing a facilitation center or facilitation process to get your money back. The challenge in all this is how do you enforce? We're talking about banking. If you ask any bank in India how many decrees or judgments they've got through courts and how many they could actually enforce, it's an interesting question. Because to actually go around enforcing, it means going and attaching somebody's assets, putting them up for sale, recovering the proceeds from that. That's one route. A second route is trying to make the person insolvent or shut down a company, etc. The third is putting him in jail. Putting him in jail rarely happens. It's there on the statute book, but rarely happens. So if you can use a facility like an arbitrator, the only point I would like to make is the tendency is you'll be advised in arbitration, have a retired judge or a lawyer as an arbitrator. It doesn't necessarily work. If you expect a simple dispute, have someone from industry, he'll understand the issues much better. And we often recommend this. For example, an architectural contract with a customer, another architect will understand it far easier than a judge or a lawyer.
It is said that practically arbitration is quite expensive. So is this a recommended route for startups?
What is expensive in arbitration? Let's try and enumerate it because the general answer again may not help you. The fees of the arbitrator, the fees of the venue, because you have to book a venue to have your arbitration, the fees of the support staff if you need a stenographer, etc., the fees of your lawyer. Okay, all this adds up, undoubtedly. When you go to court, once you pay your court fees, it doesn't matter if there's one hearing or 500 hearings. The government takes care of it, your court fees are done. In arbitration, it's not like that. For every hearing, you need a venue, a room, you need a stenographer, etc., etc. Like I said earlier, if you have an arbitrator to suit your requirements, it can work much better.
How effective is the clause on indemnity in terms of internet business in India with the respect to suppliers and vendors?
Okay, let's first discuss what indemnity is because it's easy to use a term without necessarily knowing what it means. So the Contract Act provides that an obligation to pay money, either primarily or through a secondary party, is an indemnity. Okay, so let me give you an example. If I have a contract with you, to your knowledge, I've subcontracted to him. And I say to you, guess what, if something goes wrong, look to him, don't look to me. That's a form of indemnity. In that situation, I am saved. If you try and sue me, I will join him to the suit and try and get him to pay you directly, provided he has indemnified you in the process. Now, in any contract, the reality is indemnity one quantifies the amount. In some jurisdictions, it's easier. In India, it's not necessarily as easy. So it gives you some certainty to say that if I lose through a breach of contract, you will pay me 100 rupees, for example, okay? Now, the industry doesn't matter. That's a pure contractual term. It could be industry A, B, or C. All I would say is to the extent you can quantify the loss you will suffer. It's not easy. If you can quantify it, call it indemnity. You can also call it liquidated damages. That's up to you, depending on the particular.
Service value is also the brand value.
Correct. So therefore, you can also pre-estimate the damages that you'll suffer by virtue of a breach of contract.
Many times when we enter into a contract with our vendors or with any other party, there is a clause which says that any IPR developed by you at this point of time may be ours at certain given point of time if they come to know about it. Now, at this course of time, say for example, when I'm working on a client's project and I develop a particular tool while working for him, what kind of clauses should I keep in the contract so as to I can make sure that the IPR which is generated during the course of contract stays with me and not with the person who has given me the work?
So there's a concept of work for hire under Indian law. Work for hire means if I engage your services to fulfill a certain job for me, then that particular work comes to me and the underlying intellectual property comes to me. In the course of developing that one solution for me, you may have 20 other solutions. And this is typical, for example, in advertising agencies, where to come up with one ad that is acceptable to a client, they'll go through a whole bunch of iterations. Then the contract may or may not say one way or the other, but it should say that all iterations which, from your point of view, which you don't take and you don't pay me for are mine, and I can do what I want. So similarly for what you are developing, if you can have a term that says that other than the particular IP that is being transferred to you, for which you are paying me, all iterations are mine, one. Secondly, you can also say that any other use that I can put this IP to, other than the use you want it for, is mine. It's a negotiation, but you can say that. You can also say any other developments based upon the IP, which I'm going to give you now, but developments are again mine. So there are three avenues which you can try and put into a contract to preserve whatever value that you feel you can generate later.
All right, there you have it, the basics of contracts. But you're likely to run into specific situations that require specific solutions. For that, you have to write into us, because at the end of this series, we will be answering viewer questions. Next week, we take you through the terms in a term sheet. Make sure you tune in.
Rules of the Startup Game. The Startup Guide to Startups.